Good afternoon. Welcome to the Public Service Commission of South Carolina. It's Monday, July 11th. We are here for some oral arguments in docket number 2022-188-EC. Our first order of business will be to conduct a roll call of commissioners. Present in the hearing room, we have Commissioner Jay Williams, Vice Chair Powers, Commissioner Thomas, and myself, Chairman Belser. Present virtually, we have Commissioner C. Williams, Commissioner Irvin, and Commissioner Caston. Let me recognize our staff counsel, Ms. Mosier, to read the docket, please.
Thank you, Madam Chair. Good afternoon, commissioners and parties. We are here today for an oral argument in docket number 2022-188-EC, which is the matter of Spectrum Southeast LLC versus York Electric Cooperative Incorporated. The parties are here regarding a motion to strike portions of the petition to intervene and answer of York Electric Cooperative and the Electric Cooperatives of South Carolina. It should be noted that the Electric Cooperatives of South Carolina's petition to intervene has not yet been ruled upon, but both Spectrum Southeast and York Electric Cooperative have indicated their consent to the matter of intervention being decided after this oral argument. The proceeding has been scheduled for today, July 11th, 2022 at 2 p.m. All parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Ms. Mosier. We'll take appearances from the parties. Who's representing Spectrum Southeast LLC?
Good afternoon, Chair Belser, Vice Chair Powers, members of the Commission. My name is Mitchell Willoughby, and with me from the firm of Willoughby and Hafer, with me today is Paul Warner of the firm of Shepard Mullen, and together we will be representing a Spectrum Southeast and Charter Communications in this proceeding. I would also say for the proceeding and for the record, Chair Belser, that my firm has entered an appearance as well on behalf of the South Carolina Cable Television Association. So we appear today on their behalf as well.
Thank you, Mr. Willoughby. I note that Mr. Werner has a petition or request for pro hoc vici admission pending before the commission, but we will proceed today if I'm not sure if he's presenting or not, but if he is, we will certainly acknowledge that. I think it is on the agenda for Thursday's business meeting to rule on several petitions pro hoc vici admission. So, and who's present for the respondent, York Electric Cooperative?
Madam Chair, Frank Ellerby, Robinson Gray Law Firm, representing York Electric Cooperative, also Electric Cooperatives of South Carolina, who has petition intervened pending. With me, I have Chris McDonald of the Tinkin Law Firm in Charleston, and Chris Kuhn, General Counsel of the Electric Cooperatives of South Carolina. Thank you, Madam Chair and members of the Commission.
Thank you, Mr. Ellerby. Welcome, gentlemen. AT&T Carolinas.
Madam Chair, it's Patrick Turner, and I sincerely apologize. I know I was the reason that we got started a little bit late, and I'm sorry. That's my inability to do technical things, but thank y'all, and I sincerely appreciate it, and I'm here for AT&T South Carolina.
Thank you, Mr. Turner. I share your pain on the technology front. South Carolina Telephone Coalition.
Having my own technical difficulties, Madam Chair, I apologize. Brad Wright with the firm of Burr Foreman on behalf of the South Carolina Telephone Coalition. I'm joined by Peg Fox, my co-counsel, also with Burr Foreman. I believe Mr. Bowen is participating remotely, also with Burr Foreman, also on behalf of the South Carolina Telephone Coalition.
Thank you, Mr. Wright. South Carolina South Carolina Cable Television, and Mr. Willoughby's already indicated an appearance for them. Office of Regulatory Staff.
Good afternoon, Madam Chair and Mr. Vice Chair and members of the Commission. My name is Chris Huber, and I'm here on behalf of the Office of Regulatory Staff. Thank you.
Thank you, Mr. Huber. Any preliminary matters before we get started from anyone? Can I just ask the parties if you can... Was that someone needing to be recognized? Okay.
That was my chair squeaking, Madam Chair, sorry.
May I just ask the parties if you could give us an indication on who's intending to provide argument today, please?
Madam Chair, Mitchell Willoughby speaking. I will, on behalf of the petitioner in this case, I will make an opening presentation. We would respectfully reserve time for Mr. Warner to make a reply after the other parties have made arguments in this case. It is our motion to present, and so we would request the privilege of being able to provide a reply as well.
Thank you. York.
I'll be speaking on behalf of York, Madam Chair.
Any of the other parties wanting to be heard today? Just trying to get an idea where we are. Thank you very much. Anything else? Okay. Mr. Willoughby, you're recognized.
Thank you, Madam Chair, members of the Commission. Thank you all for making time on your calendar to hear us today. We appreciate that very much. This is a very important issue that we bring to you. This is the very first case that is to be decided under the Broadband Accessibility Act. And we've presented to the Commission a very straightforward, specific legal issue that we wish for you to provide an interpretation of the Broadband Accessibility Act, which you are permitted to do by the jurisdictional authority that you were given. To guide my presentation this afternoon, I have a PowerPoint that I've given to the court reporter, and hopefully that has been, copies of that have been provided to you as well. And I will try to see if I can make this thing work. Yes, so it's on the screen.
May I ask, has this been distributed to the other parties as well?
Yes.
Thank you.
We've
If it's coming to us, I just want to make sure it's coming to them.
Absolutely. We knew that question would be coming, and so I've passed it out at the same time I gave it to the court reporter.
Thank you.
And we'll be happy to provide an electronic version to the court reporter after this proceeding is concluded. The issue that we bring to you today is not the question of the merits, but this is a procedural question that we've brought to the Commission in the form of a motion to strike. And the motion to strike is designed to basically focus the hearing on the issue that Charter has presented in this case. The second page of our presentation enumerates the slides. You'll see that I'm going through several slides, an introduction, focus on the single issue that's raised for determination, talk about the jurisdictional limits, talk about the way that the co-ops, through their petition to intervene, appear to us to be seeking to rewrite and broaden this proceeding. The motion, we believe, properly limits the focus of this hearing to get the Commission to really focus purely on the legislative intent and make an interpretation of the statutory framework that's been provided by the General Assembly. The Rule 12F motion is a perfect vehicle by which to bring this procedural issue to the Commission's attention. The Commission has used motions such as motions to strike in the past, has ruled on them in the past, literally for decades. So there's nothing new. Granting the motion would promote judicial economy, save everybody's time and resources. And the co-ops have made a couple of arguments that I'll address throughout this presentation. Moving to my third slide, introduction. Just a little history of this proceeding. Charter filed its petition on May the 19th of 2022. And as I mentioned, it's the first proceeding that we're aware of under the Broadband Accessibility Act. And why is this proceeding important today? Because we ask you in this motion to strike to basically define and clarify the scope of the proceeding. We think that is important given the limited time that the Commission has in terms of considering the issue, but it's also important to give guidance to all of the parties as to the scope of the testimony and to the scope of the discovery that they might be permitted to employ in this case. The fundamental dispute is a very straightforward issue. We assert that the issue that we've presented, and I'll address that in just a minute, is a single, straightforward legal issue. And we present it in a fashion that the Commission can give all of the parties a straightforward and clear answer to that question. The co-ops in their answer and Petition intervened filed on behalf of the electric cooperatives of South Carolina would seek to broaden the inquiry, much broader, more nebulous, if you will, unclear as to the issues that they wish to inject into this proceeding, and we would argue would be beyond the Commission's jurisdiction under the Broadband Accessibility Act, which a charter invoked by the filing of its petition back on May 19. And we'll discuss that in just a second. In the fourth slide that we have here, I focus on an absolute quote directly from the petition that we filed. In the petition, Charter asked the Commission to answer a limited but critical legal question, and that is whether an electric cooperative pole owner may deny access to its poles based on construction standards that exceeds those of the National Electric Safety Code. We assert that the answer to that question is no, they cannot. Obviously, the co-ops disagree with that, and that would be the subject of the proceeding. The co-ops in their responsive documents imply that we, Charter, is saying that they cannot use any standard other than the National Electric Safety Code. If for some reason they think that they wish to have a standard that might be more stringent in a particular situation, and we don't say that at all. As this Commission knows, most issues boil down to money issues, and this is a money issue as well. The question becomes, when the General Assembly chose to use the words that the National Electric Safety Code would be the standard to the extent not prohibited, they didn't say that you couldn't use another standard, but you just couldn't charge the cost, the make-ready cost, on to the communication service provider that was seeking access to the poles. And that is a very important distinction. So the money question becomes, who pays the cost? If they wish to have a standard differently than the NESC, who pays the cost for that different standard? If you don't have a standard, and the General Assembly, we believe, imposed one by reference to the National Electric Safety Code, you have no standard. Every co-op could have a different standard. And in fact, you may have a co-op that would say, we're going to have a standard, one standard for this run of wire or this run of poles. And on a different run of poles, we want a different standard. You could have 50, 100. There would never be any way that anyone could comply. We don't think that's what the General Assembly intended to do. What our motion, though, does is focuses the question of this proceeding on that one simple issue, is how do you interpret the use by the General Assembly of reference to the National Electric Safety Code. That is the issue that we wish to be decided. That section that we've referenced to the Commission focuses your attention on section 58-9-3030A. And that is the section that contains the language to which we refer and to which we seek your guidance through an interpretation. So let's see what the code says and the reason what we've given the Commission to address. What does the code allow the Commission to do? The Broadband Accessibility Act. What does it allow the Commission to do when you've received a petition? When we file the petition, of course, as all of you know, we've invoked your jurisdiction. We've said, under this statutory provision, we wish for you to take jurisdiction over this issue and give us a determination. It's not an issue that's undefined. That's the reason we're here. It's a clear target bullet point shot. So slide 5 addresses the jurisdictional limits, if you will, that the BAA provides to the Commission and to guide you in terms of considering and making a determination. The Broadband Accessibility Act gives Charter the right to file the petition, and then this Commission, when we file the Commission, has a jurisdictional responsibility to determine just and reasonable rates, terms, and conditions. In this case, it's terms and conditions that we're asking the Commission to look at. There's no rate specifically involved in this question for pole attachments, and the Commission must make, and I've highlighted the magic words, such determination, time period, within 180 days of the filing, and then for that determination. So that's the code section 58-9-3030A2 guides the Commission as to, okay, we've got a petition, it's asked for a ruling, what is our focus? And your focus, as given to you by the Broadband Accessibility Act and is given to you by the intent of the General Assembly, is to focus on that issue that is presented to the Commission. In this case, we have raised a single issue, and that issue is, as I described before, whether a cooperative can deny access to poles by using construction standards that exceeds those of the NESC. That is the question. Didn't range far and wide. We focus the question on that one specific legal question that we wish to have a determination to. Correspondingly, the Commission's jurisdiction is limited to determining that specific legal question. We think, and we believe the statutory language of the BAA supports this, we don't think that the co-ops can use their answer to broaden the inquiry. We don't think they can use the answer to say, well, let's have a far-ranging inquiry. And in fact, if you read their documents, they haven't defined how far-ranging that may be.
So the question we would ask of them is, what do you intend? How broad do you wish to make this proceeding? And what is your basis for doing that? We don't think they can broaden it at all. We think the only question for the Commission's consideration is that one specific, targeted, rifle shot question of, can the co-op deny access to polls, to their polls, by saying we're going to impose a construction standard that exceeds those of the National Electric Safety Code. And as I said before, we would have no objections if they wanted a different standard, if they said, for some reason, we would want to impose a more stringent standard for this 5-mile run, as long as they bore the cost of that specific or more stringent standard. That is the question. Who is responsible for making the make-ready a cost? Because if you make the standard more stringent, you run into situations where more poles have to be attached, there's more time limit involved, there's more delay involved, and as a consequence, the ability to expand the service into every rural area in the state is somewhat delayed. We also believe, given the language that I've quoted up in the first bullet item here, that the Broadband Accessibility Act does not provides the Commission with a look to expand the proceeding either. I think the Commission, in all due respect, we would respectfully ask that your jurisdiction is limited and focused on the question that is presented to you without going beyond that question. Now let's look at what some of the issues are that we have to deal with on slide 6. The co-ops cannot, by their answer, rewrite the single issue that we presented. And what I've focused on here is pulled right out of their petition to intervene and answer is language that they used. They recognize, and I think this is extremely critical, they recognize in its petition to determine just and reasonable terms and conditions, Charter seeks a determination from the Commission on a specific legal issue. They were absolutely right in identifying that that's the issue that's been presented. They recognize that. They know that. But then what do? Then they go, instead, the Commission should issue a scheduling order providing a pre-filing of testimony for a much broader range issue. And the question I would ask again is, what is the limits of that? What inquiries do they wish to make? And if those inquiries intrude in any way beyond the specific statutory interpretation that we have proposed to the Commission, then we don't think it would be appropriate for the hearing to be expanded to include that inquiry. So what did we choose to use to bring this matter to your attention? We chose a motion, we called it a motion to strike. Perfectly appropriate, widely recognized by the rules of civil procedure, used before this Commission on many occasions. I've used it on many occasions before. Had judges ask, did you file a motion to strike? So it's a widely used proceeding or procedural tool that is acknowledged. In this case, we simply asked through our motion to strike that by granting it, you would be saying that we acknowledge that the proceeding is a targeted issue, and we are clarifying what issues we're going to focus our attention on for determining the interpretation of the statute. If you'll look at our motion to strike, we only focused on striking those portions of the answer that seek to improperly expand the scope. That was our total focus. And you will also note that our motion to strike was also tailored to conform the proceeding to the contours of the commission's jurisdiction. That is, that the commission has jurisdiction to determine the issue that's been presented, and the statutory language supports that. The co-ops have, and I'll use that general term to refer to both York and the electric cooperative, cooperatives of South Carolina, the association, collective term, I'll refer to them as co-ops. They argue that a 12B or 12F motion to strike, is not an appropriate tool. We would argue that that's widely, that's incorrect. It's incorrect. The motion to strike is often used to eliminate immaterial and impertinent matters that someone might introduce or seek to introduce into a proceeding to make it more confusing, to make it more broad, to elongate the proceeding. All of those things would be designed to be resolved by the motion to strike. And I've got three issues here that we've pulled from research. For example, the Rule 12F motion itself says the court may order stricken from pleadings any insufficient defense or any redundant, immaterial, impertinent. We argue that the material that the co-ops are seeking to introduce in this particular case are immaterial and impertinent. You would note that the purposes of the motion, very valid purpose, is to avoid both the waste of time and money that can come with unnecessarily litigating an issue that it does not need to be litigated. You see from Amjura, we've indicated that immaterial material is material that is outside the scope of the action, and we argue that that's applicable here. Impertinent matters, for purposes of Rule 12S, consist of any allegation not relevant, not responsive or relevant to the issues involved in the action. So the information that the co-ops seek to introduce in this proceeding is neither pertinent nor material to the issue that the commission has at hand, which is that simple, straightforward issue of determining an interpretation of the of Section 3030, subsection A. I would also direct your attention that the commission, as I mentioned, has had a long practice of permitting motions. In fact, your rule of practice and procedure of 103-829 basically says motions may be filed. So we could have called it just a motion. We chose to call it a motion to strike, and it's a perfect vehicle to bring this issue to the commission's attention. I focus your attention all the way back to an order that the commission issued in 1995, in the application of Bell South Telecommunications. And the co-ops have indicated that, well, the commission's rules of practice and procedure only allow you to look to the rules of civil procedure for guidance if it's a discovery issue. And I don't believe that's not the case. This order makes clear that it's not the case. In that order, you cited or you stated the commission believes that much as the South Carolina Rules of Civil Procedure govern all discovery matters not covered in commission regulations, the commission must look to the remainder of the South Carolina Rules of Civil Procedure for matters not governed in the commission's own rules of practice and procedure. So we don't think there's any question that this commission has a long history of making reference to the rules of civil procedure when its own rules have a gap or are silent on an issue. And then the other point is the commission has considered numerous Rule 12 motions in the past, including motions to strike. And we've just got an example, but there are many examples that we could pull for you. I also mentioned to you that there's a policy reason beyond just the statutory interpretation that supports, if you will, the idea that you should grant the motion, and that is promotion of judicial economy. This allows us to, by granting the motion, it allows everybody's attention to be focused on the narrow issue that we've presented to the commission. It's a critical issue. It's a threshold issue. It's an issue that needs to be determined so that we all will know what the construction standards are and how we might be confronted and how we might have to deal with those construction standards. It also allows discovery to be appropriately focused in the case, and it also puts the commission in a position to focus on the straightforward legal issue that we've presented without having to wade through a lot of extraneous information that what may not be of any real benefit. Take, for example, one of the things the co-ops had indicated that they wish to be able to show is how we've been doing it in the past, and that we've been using different standards from 2004 and earlier and later. Well, the answer is the Broadband Accessibility Act was passed in September of 2020. So the question becomes, what does the Broadband Accessibility Act provide the commission and the parties in terms of guidance? Doesn't matter what we might have done at some time in the past that may be interesting, but it's not necessarily relevant to a determination as to what is the standard that the General Assembly intended and did provide to the parties. And as all of you know, that your most important rule of construction is determining what the legislative intent was for the passage of a particular section of the law. And that's the issue that you would wish to focus your attention on and make a determination. So let's address the two arguments, and I've touched on them as I've gone through this presentation. There are two arguments that the co-ops raise. Both of them fail. The first argument is that a motion to strike is essentially not authorized. That simply is not true. The commission has a long history of considering Rule 12 motions under the Rules of Civil Procedure, and they look to the Rules of Civil Procedure to guide you whenever your own rules do not have specific guidance about how a rule should be decided. And the second argument is that more expansive discovery and fact-finding is needed to aid the commission's determination. That's also untrue. The second argument fails. Basically, that's an effort by the co-ops to essentially rewrite the petition and allow the proceeding to venture into inquiries that are unnecessary and will be time-consuming to decide that limited issue that we presented i.e. the interpretation of the code section that we've asked you to interpret. We raise a simple legal issue, and as you know, the best evidence of what the General Assembly attended is the language that they chose to use in the particular statute that may be at question. And the third reason that we think the Commission must grant our motion is that because the Broadband Accessibility Act as well directs the Commission's attention to deciding that question that has been presented by the party that filed the petition. So, in summary, a charter's petition raises one simple legal issue for determination, and a fact that's openly acknowledged by the co-ops. And as I've mentioned to you earlier, the co-ops acknowledge that charter seeks a determination from the Commission on a specific legal issue. We think charter is entitled under the law to have that single legal issue interpreted, and we think the Commission's jurisdiction is limited to making that determination on that specific issue. We don't think there's anything in the Broadband Accessibility Act that allows the co-ops to basically rewrite our petition. As all of you know, we are the masters of our petition, masters of our complaint. We choose the issues that we wish to present to the Commission for its determination, and that right cannot be commandeered or taken from us. We think the tool that we've used, the motion to strike, is an appropriate procedural tool to be used, but if you wish that we had used a different procedural tool, it makes no moment. Your rules permit us to file motions. We filed a motion that we styled motion to strike. We believe the statute authorizes the Commission to limit the proceeding to the issue that we have advanced. Your rules basically say as much, and also the statute, we believe, limits the jurisdiction to the issue that's been presented. So for the reasons that that we set forth in our writings, both the motion and our reply to the response, and the information that I provided here to you today in this PowerPoint presentation, for all of those reasons, Charter respectfully requests that the Commission grant its motion to strike, clarify the extent of this proceeding, and allow the parties to focus their attention on providing information to the Commission that addresses that simple, straightforward, single legal issue, which is a question of whether the co-op can deny access to poles by using construction standards that exceed those of the National Electric Safety Code. I thank you very much for your attention. I'd be happy to answer any questions, or we can wait until the other parties have had a chance to respond.
Commissioners, any questions for Mr. Willoughby at this time? Hearing none, thank you, Mr. Willoughby.
Thank you very much.
Mr. Ellaby.
Thank you, Madam Chair, Mr. Vice Chair, members of the Commission. Frank Ellerby, speaking on behalf of York Electric Cooperative and the co-ops and responding to the motion. Excuse my voice. I have tested repeatedly and have been negative every time. So, but I guess colds are still out there. I'm going to give you a little bit of background about why this case, why the act was passed, and why the electric cooperatives are the first entity to be before you on a matter involving attachments to their poles by communications providers. The investor-owned utilities in South Carolina and around the country have been subject to the jurisdiction of the Federal Communications Commission over these types of issues for decades, since going back to the 1970s. And there's been a ton of litigation about that involving investor-owned utilities. Until 2020, as Mr. Willoughby indicated, there was no such rule that applied to electric cooperatives. However, as part of the Broadband Accessibility Act, the General Assembly made certain of those rules applicable to electric cooperatives. And the reason it was a legislative trade-off, as y'all are familiar with, the main purpose of the Broadband Accessibility Act was to make it clear that electric cooperatives could provide broadband service. The General Assembly was worried about the lack of broadband service in rural areas of South Carolina. They knew electric cooperatives were well situated with facilities out in rural parts of South Carolina, that electric cooperatives were responsive to their members, people who live in rural parts of South Carolina, and that the electric cooperatives would be a good bet to provide broadband service in rural areas. So the Broadband Accessibility Act clarifies that electric cooperatives can go into broadband through a number of provisions, and the concern was raised by other stakeholders. Well, what about the possibility, since there will be some competition, what about the possibility of cooperatives using their greater access to facilities to gain a competitive advantage? And the General Assembly addressed that by saying co-ops have an obligation to provide just and reasonable access to their poles and rights of way and facilities, and gave this commission the authority under Section 58(9)3030 to, if negotiations on a pole attachment agreement were unsuccessful, gave the commission the authority to determine just and reasonable rate terms and conditions of the agreement. And that's what this case is about. That's what Charter's caption says the case is about. Petition to determine just and reasonable terms and conditions. It's not petition to determine the applicability of National Electric Safety Code. It's not petition to require co-ops to follow the National Electric Safety Code as the maximum clearance requirements. It is a petition to determine just and reasonable terms and conditions. And that's what the case is about. We are not expanding what the case is about. That's what this commission's jurisdiction. Y'all get to hear from the parties, and you get to determine what the just and reasonable terms and conditions are. Charter's position is that the act itself made the National Electric Safety Code clearance requirements. And let me pause. Clearance means how far you have between facilities attached to a pole. That would be one clearance. Ground clearance is from the lowest line on a pole down to the ground is a ground clearance. So there are various, and the complexity of the requirements regarding those clearance requirements is substantial. It is very complicated. And we believe, and there is not a one-page list of clearance requirements that everybody can go and apply. We think it's critically important for y'all to hear from witnesses in this case to have some greater understanding of the clearances and how the clearances apply, and the purpose of the clearances, all these things we intend to get into. The position of Charter is National Electric Safety. The General Assembly adopted National Electric Safety Code as the maximum clearance requirements. Our position of York and ECSC is that's wrong. The BAA did not do that, and York's clearances that York was insisting on in the negotiation are just and reasonable. And we believe that's absolutely a question before y'all for determination in this proceeding, is were the clearance requirements that York asked for just and reasonable? And we want to call witnesses. We want to put on our defense. That's our answer to the complaint. Y'all may not end up agreeing with us, but we are at the pleading stage of this case. We are setting out what we think our answer, our defenses are. We want an opportunity to pre-file our testimony, put on our testimony. Charter can object to that testimony. Y'all can decide whether it's relevant to the issues before you. None of that has to be done today. None of that should be done at this pleading stage of the case. Part of, if I could direct your attention, and y'all might just want to make a note of this, I'm going to read to you from part of paragraph 9 of Charter's petition in this case. The petition says, York's imposition of requirements far in excess of the NESC flout the state's law cannot be based on any reasonable need for safety or sound engineering. They have put into issue in their pleading whether York's clearance requirements are based on reasonable needs for safety and sound engineering. I submit to y'all that under the South Carolina Constitution, Article 1, Section 22, we are entitled to be heard on that issue. We're entitled to be heard on whether York's clearance requirements are reasonable, non-discriminatory, and provide reasonable terms and conditions for Charter to attach to. We want to give you, and I think I can, y'all may be wondering what's really going on here. I don't think Charter wants y'all to hear from the York witnesses about the background of how York came to establish the clearance requirements that it has come to establish and that it has been insisting on during the negotiation. We want to call those witnesses and have them testify, have y'all be able to hear from them directly and ask questions of them, because that background is very much relevant to the issues that y'all are going to have to decide. It's even more imperative for y'all to hear that because this commission has never had to deal with these issues before. Duke and Dominion don't get to come to y'all. They go to the FCC when they have issues like this. So this is not only a matter of first impression under the Broadband Accessibility Act, it's a matter of first impression under South Carolina law for this commission to be dealing with pole attachment issues. Hearing from the witnesses at York Electric Cooperative who will tell you about their experience and tell you why the reasons that they impose the requirements and that they think these are reasonable and necessary will be extremely beneficial to y'all. We also plan to call expert witnesses. Of course, those folks from York, I believe, are qualified as experts, and we'll ask them for their opinions. We also plan to call an expert witness, or maybe several, we don't know, to give you all background on the National Electric Safety Code and how it came to be, what's involved with the National Electric Safety Code, how complex it is, how many different engineering determinations have to be made under the National Electric Safety Code to determine what clearances should apply. We believe that what the General Assembly intended when they said just and reasonable terms was not some cookie cutter formula that you would go to a book and pull out. We believe that if there was a dispute about it, parties would come before y'all, they would each make their case, and y'all would determine what are the reasonable terms and conditions based on the evidence. Charter would have y'all determine that statute, that question, novel question, first impression, statutory interpretation in a vacuum without any background on what's been the history of pole attachments, what have been the issues, what are the safety and reliability concerns that are addressed by the National Electric Safety Code. I don't want to get too far into the merits. However, I will tell y'all that when we talk to engineers and we tell them that Charter's position is the National Electric Safety Code is to be applied as the maximum clearance standards, they are mystified. National Electric Safety Code has never been intended to be any maximum clearance requirements. Y'all have a regulation that says the National Electric Safety Code are minimum safety requirements. They're minimum requirements. And nothing in the National Electric Safety Code prevents a company from having greater clearance requirements. The General Assembly did not adopt the National Electric Safety Code as maximum clearances. And we believe that y'all will conclude that after you, and it will be helpful to you to hear from the engineers, the people in the field who actually work with this, and the experts to talk about the code. Charter's motion, in addition to being unfair to this commission by asking y'all to rule on these issues now at a preliminary stage in a vacuum without having seen pre-filed testimony or heard from the witnesses or had an opportunity to talk to the witnesses, Charter's motion is unfair to the co-ops also. Charter's motion here says this case is a narrow, very targeted legal issue about what was in the BAA. But look at their petition. It's got pages and pages of policy arguments. It's got citations to newspaper articles, quotes from newspaper articles. It's got citations to engineering handbooks, selected citations to handbooks. It's got their press releases, by Charter press releases. They have loaded up the record as attachment, as references in their petition, and attached to their petition are 10 pages of emails, selected emails back and forth between counsel for Charter and York, which are already before this. So for them to say it's a clean legal issue that doesn't require elaboration and testimony and extraneous information is a little bit unfair after they've already loaded up their petition with all these policy arguments. So we think that's utterly unfair and just stunning for them to take the position that we don't have the ability to meet their allegations, that that York's requirements cannot be based on a reasonable need for safety or sound engineering. They put that in their petition. We want to meet that allegation. We want to explain the reasons. We want to explain why those clearance requirements have been in place for many years, and why they've been applied fairly and in a non-discriminatory fashion across all attachers. And we want to put witnesses up to do that. We want y'all to have an opportunity to hear from these people. And for them to say that we shouldn't be able to put that testimony up after they have put those sorts of allegations in their petition is stunning and should be rejected by the commission. Nothing that we have in our answer, nothing that I'm saying here today would suggest that Charter shouldn't be allowed to make the legal argument that they want to make. Of course, they can argue that their interpretation of the Broadband Accessibility Act, y'all will be able to decide that, as this commission has typically done over the years that I have practiced before the commission. These sorts of preliminary motions are typically taken under advisement. You hear from the witnesses, you gather information from the witnesses, you question the witnesses, and you decide those legal issues at a later time. There's absolutely nothing to prevent y'all from having a full hearing on this matter and then deciding the Charter legal issue as part of your disposition of the case. And at that point, if they persuade you that they're right, that the Broadband Accessibility Act adopted the National Electric Safety Code as maximum requirements, then your ruling could reflect that. But there's absolutely no reason. And judicial economy, I would suggest that judicial economy would have been better served by not making a motion to strike an answer at this preliminary stage when this commission has had no opportunity to get involved in the case, read testimony, have an in-depth understanding. And when it is the first time an issue, even like this issue, has come before y'all. So we think this, there's no reason to grant the motion. It will not prejudice charter in any way, shape, or form. It will ensure that y'all get more information and a better basis for deciding the case when you get to that point. And for all of those reasons, we urge y'all to deny the motion to strike. Thank you. Glad to answer any questions.
Commissioners, any questions of Mr. Ellerby at this time? Hearing none. Mr. Werner? None of the other parties, right? Okay. Mr. Werner, you're recognized.
Thank you very much, and good afternoon. Madam Chair, Mr. Vice Chair, and members of the Commission, thank you very much for allowing me some time here on reply. Let me just start by saying this. I think we all agree that this is going to be a very important proceeding for this Commission. This is a new act. Our petition presents a novel question, a question of first impression for this Commission, and it arises under the lengthiest and, to us, most important section of the Broadband Accessibility Act, which is titled Non-Discriminatory Access. It's the longest provision, and the petition we bring comes under the very first provision of that statute. Now, this is a procedural matter, and there's been some discussion of the merits, and I'd like to just focus my comments on procedure, but I will say, just to clarify and reemphasize what Mr. Willoughby said earlier, this is not a question about whether the NESC in and of itself is the end-all be-all. What this petition and what this proceeding is about ultimately is about what this particular text of subsection A means when it says access shall not be denied except to the extent prohibited by the National Electrical Safety Code. Now, we're not saying that the cooperatives cannot impose standards beyond the NESC. What we are saying is that they cannot deny access to their poles beyond standards that exceed the NESC, and they cannot shift costs for those excessive standards to us, which of course will have consequences for broadband deployment across rural areas in the state. But let me just focus on the procedural issue, because I think we're a little bit like ships passing in the night on that question. This is a commission of limited jurisdiction. The commission is entitled jurisdictionally to hear complaints and petitions about specific terms and about whether they are unjust or unreasonable. The commission does not have generic jurisdiction to assess at some broad level of generality whether terms are just or reasonable in the abstract. Here, that's particularly important because the parties have not agreed on any terms. That is very clear in the chronology here, and it will come out in the evidence. There are no agreed terms. So it is not as if the commission can assess whether a broader basket of rates, terms, and conditions are reasonable. The parties reach an impasse on a specific issue, and that is the issue that is the focus of our petition, and it is the one that we specifically teed up for this commission to resolve. Now, we think that fundamentally, at the end of the day, is a legal question, not a factual question. But we understand that the parties can present evidence. Our issue is the sections of the answer that seem to focus on a far broader inquiry. And if you look at paragraphs 1, paragraph 3, and paragraph 13, the cooperatives reference whether or not York has met its obligations under the Act. That is not the question for this proceeding. The question of this proceeding is whether or not access can be denied on standards that exceed the NESC. So our concern and our motion to strike was really motivated by this Himalayan level abstraction that is introduced through the motion to intervene and answer. But we do not deny that the parties should be permitted to make arguments and to submit evidence, whether lay witnesses or expert testimony, geared towards the specific question that is teed up in our petition. We understand that that testimony should come in, and we intend to introduce that testimony ourselves. We don't think that the background is necessarily relevant when interpreting the specific legal text of the statute itself, but we understand that evidence is going to be allowed in, and we have our own perspective on the background, and we have our own perspective on the merits questions and the expert issues around the meaning of the NESC. We don't agree with the utilities' perspectives on that, and we heard a little bit about that today, and we intend to address that through this proceeding. Our only issue is we should not be having to address new issues that may be raised during the course of this proceeding by the interveners or the cooperatives. The proceeding fundamentally needs to be focused on the issue that we presented in our petition itself. With that, I'm happy to answer any questions.
Commissioners, any questions for Mr. Werner at this time? Hearing none, thank you.
Thank you.
I'd like to thank all counsel for appearing here today. I'd like to thank the attorneys presenting arguments for your arguments and your positions. We will close this oral argument and notify you of how we will proceed in the future. Thank you very much. Have a good afternoon.
Thank you.